I'm Nate Eaton with some breaking news in the investigation into the shooting of Victor Perez. He's the 17-year-old Pocatello boy who was shot multiple times by Pocatello police officers back in April. He died several days after that shooting. Since then, the Office of the Attorney General in Idaho has been investigating and interviewing people, and they even hired an expert to look into the case. And they, as of this morning, have announced that they will not be charging the officers who were involved in this shooting. It was 4 officers with the Pocatello Police Department who will not face criminal charges. Now, I'm learning about this from a letter that was sent from Jeff Nye. He is the Deputy Attorney General in the Criminal Division for the AG's office. He sent this letter to Bannock prosecutor Ian Johnson. And how the Attorney General ended up with this case is the Bannock County Prosecutor's Office asked them to investigate. They handed the case over to them after the Eastern Idaho Critical Incident Task Force completed their investigation. So the shooting happened in April. The Critical Incident Task Force conducted an investigation, then handed their investigation off to the Attorney General's office, who now, after 6-7 months almost, has said that they will not be charging the officers. Now, I have the letter here. It's 12 pages. I want to go through it with you. Before we do that, I want to play the video that has been seen millions of times around the world of that shooting incident that took place back on April 5th of 2025. This is a video that was taken from a neighbor across the street with their cell phone as they were on the phone with police as a situation was unfolding across the street. I'll play the video. It is disturbing, I know, for many of you, so you can turn away. I'll play about 1 minute of it, and then I will go through the letter from the Attorney General.
And there's a blue car parked on the street next to it. Cool, I can hear the sirens.
Okay, that is all I will play of that video. You can go watch the whole thing on our website, along with the other videos that I may reference tonight. There's police body camera footage that the city released a few months ago, along with some dispatch calls. The reason that the Attorney General's office says they are not pursuing charges against these officers is that they say there is not enough evidence to prove beyond a reasonable doubt. They don't have enough evidence to prove beyond a reasonable doubt that the 4 officers who discharged their weapons were not justified in using deadly force. And there's 6 reasons why. There's 6 factors, they say. I want to go through those. Before I go through those, though, for those of you that are brand new to this case, the video is shocking. It is disturbing. It is a tragedy. In fact, Jeff Nye begins the letter toward the top. He says, the death of 17-year-old Victor Perez was a tragedy. The public release of the videos of the officers shooting Perez were understandably met with public outrage. And he says their office was brought in to only investigate the criminal matter on if these officers should be charged. They have nothing to do with the civil lawsuits that are underway. They have nothing to do with the employment of the officers. That's done through Pocatello Police. They are simply asked to decide whether laws were broken by the officers who fired the shots. So there were 6 key factors that he went through. But let's go back to that. Victor Perez, 17 years old, has developmental delays, including autism. This is according to the autopsy report. Autism, aggressive behavior, abnormal gait, and other medical conditions. He's nonverbal. His family tried to keep him away from knives for his protection and the protection of those around him. On April 5th, he somehow got a hold of a 9-inch kitchen knife, a knife with a 9-inch blade. Security video from the day, which we've shown you before on East Idaho News, shows his family, including his grandpa, his mother, and his 16-year-old sister, trying to contain him in the backyard. There's a 4-foot chain link fence around the backyard. You saw it in that video. A nearby person, a neighbor, called 911, said there was some sort of disturbance going on. The 911 caller said that a man appeared to be intoxicated and was wielding a knife and trying to stab other individuals. He said one man hit the male with a knife in the head with a log, but the male with the knife continued trying to stab others. The struggle between Perez and his family lasted approximately 13 minutes before police arrived. The dispatcher requested that 4 officers respond. That was more than normal to a disturbance call. The officers were each in separate cars. They did not hear the 911 caller. All they heard was from what dispatchers were telling them. Neither the dispatcher nor the responding officers had access to that video. Of course, hindsight is always 20/20. But they didn't have access to that video that I just showed you. So they didn't know. They had limited information. They didn't know that Perez was disabled and that how old he was. Now, had police been called to the house in the past? Yes, they had. But the dispatcher did not have that information at her disposal, and the officers did not know that. And it appears that these officers never themselves had gone to that property. So they get a call, there's a disturbance, there's a guy with a knife or some sort of in the backyard, something's going on. The Attorney General released the call log. It's on our website, eastidahonews.com. I'm not going to read through it. You can read through that whole thing, the CAD report. The officers arrive, they get out. 3 of the officers have Glocks. 1 has a lethal beanbag shotgun. The grandpa is leaning against the fence and says to the cops as they get up there, no, that's okay, that's okay. It's unclear, was he saying that to the cops? Like, it's okay, or it's unclear. I would imagine so, but we don't know who he was saying that to. Perez, Victor, his sister, and mom are inside the fence a few feet from him. The officers focus on Perez because he fits the description, obviously, of the report. He's laying on the ground holding a large kitchen knife. They approach the fence. As you saw in the video, they tell him to drop the knife. They command. He fails to do so. The officers start commanding him. Then, according to the report, he got up on his knees, lifted the knife in his left hand above his head, and pointed the blade toward the sky. He fell forward and caught himself using his hands. With his hands on the ground in front of him, he put his feet on the ground behind him. He stood up and took a step toward the officers. As he stepped, he put both hands on the knife in front of his body with the blade pointed up and toward the officers. All 4 officers fired their weapons as Perez continued to move toward them with the knife. Perez's failure to obey commands to drop the knife and instead to move toward the officers holding the knife appeared to the officers to mean Perez intended to do them harm. Because he failed to drop the knife, the officers started shooting. All 4 were standing along the stretch of the fence furthest from the house. 3 officers were clustered together. 2 of the 3 had taken a step or 2 away from the fence before shooting. The 3rd officer remained at the fence holding his less lethal shotgun. The front of the shotgun was opposite of the fence. The 4 officers believed that they were 4 to 10 feet away. According to the investigator, they later estimated it was more like 12 feet. They fired 14 bullets and a beanbag. It was a single volley of 14 bullets and a beanbag. All the shots were fired within the span of less than 2 seconds. 14 bullets. He died. Well, he was hit with 12 gunshot wounds. 12 gunshots. 12 bullets. In the autopsy, they found 12 wounds. Cops then did life-saving measures. Medical personnel arrived. He was rushed to the hospital, and he died about a week later. The task force came in, as I mentioned. They interviewed a bunch of people. They then handed it off to the Attorney General's office. The Attorney General's office interviewed 15 additional people. The cops did not speak to the AG. Instead, they gave them recordings and some transcripts. The Attorney General also hired a guy named Spencer Fomby. He's an experienced use of force expert, and he reviewed the investigation and gave his opinion to the officers. So the coroner finished his autopsy report on August 12th, and that was also part of this investigation. That's the background. You can go watch all the videos, as I mentioned. The state would have to prove, this is what Jeff Nye wrote, the state would have to prove that the officers committed a crime when they shot and killed Perez and that the use of lethal force was not justified. The state would have to prove both elements of the crime and the absence of justification beyond a reasonable doubt. That's the bar. That's the standard. They got to go before a jury and prove that. Jeff Nye in these 12 pages lays out why they couldn't. And the 6 key factors as to why they couldn't. 1, the only facts they can consider when deciding whether to charge are the facts known or reasonably believed by the officers at the time of the shooting. So it has to be facts the officers knew or reasonably believed at the time of the shooting. They can't take into account, according to the law, other factors. They can't take into account that video because the cops had never seen the video. They can't take into account the neighbors, whatever. We can't take into account everything that's come out, that he had disabilities, that he was nonverbal, because the cops didn't know that at the time. So you have to take all that out. None of the 4 shooting officers were aware of Perez's age or his disabilities at the time of the shooting. Mr. Nye writes, the officer's knowledge was limited to what dispatch reported, and dispatch's knowledge was limited to what the 911 caller said. Neither the 911 caller, dispatch, nor the officers were aware of Perez's age or his disabilities. Instead, the officers were told they were heading into a disturbance where an intoxicated male was trying to stab others with a knife. So that's what we know. Second, the officers decided to move to the fence surrounding the backyard when they arrived on the scene. With the benefit of hindsight and knowledge of his disabilities, we can say that it would have been better for everyone had the officers kept their distance away from the fence. But the officers were acting on the information and belief they had at the time that an intoxicated male was trying to stab other people. Believing that individuals were in danger of being stabbed, the officers chose to run toward the fence in case the officers needed to take immediate action to protect others from harm. So imagine you go before a jury and the question is, why did they get so close to the fence? They're going to say, we were running toward the problem, what we perceived as the problem. They now know that it was a different scenario, but they were running toward the problem. Looking back, yeah, they could have stood away from the fence at their cars and yelled to him, put the knife down. They didn't know that at the time. Third, the fence surrounding the backyard was 4 feet tall. The officers' decision to place themselves at the fence to protect others made them vulnerable to a knife attack from someone standing immediately on the other side of the fence. That was another factor why they say they're not charging. Fourth, under Idaho law, the officers did not have a duty to retreat from the fence before using deadly force. They didn't have to. The law did not require them to step away from the fence. One of the officers chose to remain at the fence where he was vulnerable to a knife attack from the other side of the fence. He was still in that position when the officers started shooting. Fifth reason, given the officers did not know about his disabilities, they believed the unknown male posed a risk of serious bodily injury or death. He had a knife. He refused repeated commands to drop the knife. He was moving toward the officers. He held the knife in both hands with the tip of the knife pointed toward the officers, and he was at a distance of approximately 12 feet from the officers. That's according to the letter Jeff Nye sent to the prosecutor. The final reason why they say they're not pressing charges is this use of force expert they hired provided an objective opinion. In the past, he's given opinions both in favor of officers and against them. After reviewing the facts, he said that any reasonable officer in these officers' positions, and with only the limited information they had, would have viewed the unknown male as an immediate threat of death or serious bodily injury at the time the officers started to shoot. Based on those 6 factors, the state would be unable to prove beyond a reasonable doubt that the 4 officers who discharged their weapons were not justified in using deadly force. This is Jeff Nye. He said, this is a tragic and heart-rending situation, and our sympathies go out to the family and friends of Victor Perez. It is especially tragic when viewed considering all the facts and circumstances available to us after the event. If the officers had known what we now know, our conclusions might be different. But, as previously stated, our decision must be based only on what the officers actually knew or reasonably believed at the time, and our decision must be based on laws in effect. Idaho law does not require officers to use less lethal options. A lot of you have said, why didn't they use a taser? Why didn't they use the beanbag as the one did? Why didn't they, whatever. Good questions, very good questions, good arguments, but the law doesn't require them to do so. Idaho law does not require officers to use less lethal options or to retreat when deadly force is justified. But the law also does not preclude properly trained officers from taking such steps to avoid having to take a life. So that is what they say. Now, Mr. Nye, we posted, as I said, the whole letter at eastidahonews.com. Idaho does not require a person who's defending himself or another to wait until they ascertain whether the danger is real or not. So it's not like you have to wait and say, is that a real knife in another situation, or is that a fake knife? The law doesn't require that. The Idaho is also a stand your ground law, which means any person exercising self-defense or the defense of another need not retreat from any place that person has a right to be. A person may stand his ground and defend himself or another person by the use of all force and means which would appear to be necessary to a reasonable person in a similar situation and with similar knowledge without the benefit of hindsight. So the officers repeatedly, more than 6 times, commanded the individual to drop his knife. He failed to obey that. Instead, the man struggled to stand, consistent with being intoxicated, and then moved toward the officers with the knife held out in front of him and pointed at least slightly toward the officers. So there's that. There's pictures. There is the use of force expert, as I mentioned. And then the letter ends with, I believe, 10 questions that the public has asked the Attorney General, and Jeff Nye answers them. First, how could Perez pose a threat given his disabilities? One of the reasons Perez's death is so tragic is that in reality, he likely did not pose an imminent threat of death or serious bodily injury to the officers due to his disabilities. Under Idaho law, however, whether the officer's use of force was justified depends on what the officers knew at the time. None of the officers who discharged their weapons were familiar with Perez or his disabilities. Question 2. How do you know the officers did not know? We knew we had to address this question before making a charging decision because it would alter the legal analysis. The task force's investigation revealed that officers from the Pocatello Police Department had previously responded to the Perez's home, but none of them were present at the time of the shooting in the case. Following the task force's investigation, our office's investigators conducted follow-up interviews with the officers who had previously responded to the Perez's home. These officers confirmed they had not communicated any information about Perez to the officers who discharged their weapons. Our investigators were unable to find any evidence indicating that any of the officers who discharged their weapons on April 5th had previously responded to Perez's house or had learned about Perez or his disabilities before the incident on April 5th. Question 3. Why didn't the officers look up the address of the disturbance to see if the house was flagged for mental health issues? None of the responding officers were given an address for the disturbance prior to arriving at the scene. Dispatch was working off the information provided by the 911 caller and informed the officers only that it was, quote, behind 702 North Main. Perez's residence was on North Harrison. In addition, our investigators learned during the follow-up investigation that the Pocatello Police Department does not flag residences for mental health issues. Perez's residence was therefore not flagged for mental health issues prior to April 5th, and even though the agency had responded to calls involving Perez and his mental health issues prior to April 5th. The cops had been there. They had a mental health issue with him, but the issue was the exact address was not called in on the 911 call. How does the dispatcher's report that the family does not speak English affect the analysis? All 4 officers were in full uniform in broad daylight, pointing their guns at the individual with a knife and yelling commands. The individual's response was to stand holding the knife and then move toward the officers. The officers could reasonably infer from those facts that even if this person did not understand the commands, he had no intention of cooperating with the officers and meant to do them harm, especially given that the officers were not familiar with Perez or his disabilities. Question 5. How does the grandpa's calm demeanor and statement, "It's okay," affect the analysis? The officer's body camera video suggests that both the grandpa and the sister were trying to deter the officers when they first arrived and while Perez was lying on the ground. As one of the officers acknowledged in his interview, Perez did not pose an immediate threat to the officers or others while he was lying on the ground. It was not until Perez refused commands to drop the knife, stood up, and started to approach the officers with the knife that they could reasonably believe he posed an imminent threat of death or serious bodily harm. Even if the officers saw and heard the grandpa and the sister when they first arrived, their focus understandably shifted to the man with the knife, who they were told had been trying to stab people and was refusing commands and moving toward the officers. Question 6. Couldn't the officers have stepped back from the fence to try to give themselves more time before shooting? Answer: yes, the officers could have stepped back from the fence. However, the officers were not required to do so under Idaho law. Idaho law does not impose on any person a duty to retreat from a place he has a right to be before using deadly force. 7. Couldn't the officers have kept their distance from the fence in the first place? Answer: yes, there was a wide variety of tactical decisions the officers could have made while they arrived at the scene. In fact, our use of force expert opined that the officers made a suboptimal tactic decision by closing the distance to the fence. getting too close. But he could not say their tactical decision fell outside what any reasonable officer might do in the situation. More importantly, Idaho law does not require an officer or anyone else to make a sound tactical decision before standing their ground. Regardless of the quality of the officer's tactical decisions, there's no reasonable argument that the officers did not have a right to stand on the outside of the fence surrounding the backyard when responding to a disturbance involving a male with a knife attempting to stab others. Number 8, weren't the number of shots fired by the officers excessive? An officer's use of force is generally reviewed by each round or volley of shots fired. Additional shots would only be reevaluated if there were a change in circumstances that would affect the use of force analysis. Officers typically fire more than one shot in the initial volley because if lethal force is justified, officers are taught to keep shooting until the threat is over. Here, all 4 officers fired a single volley of shots that started and ended in less than 2 seconds. The number of shots fired in part was due to the fact that 4 officers were present and all 4 officers fired their weapons. If only one officer was there, it could have only been one gun. But the same use of force analysis applies to each officer individually with respect to self-defense or defense of another. Question 9, couldn't the officers have used a taser or less lethal shotgun prior to firing their handguns? Quote, each officer was equipped with a taser, and one also carried a less lethal shotgun at the time of the shooting. However, officers in Idaho were not legally required to attempt less lethal methods before using deadly force. The relevant question is whether the use of deadly force was justified. Additionally, officers in Idaho and elsewhere are trained to respond to lethal forces, to lethal threats with lethal force. Last question. Does this mean the officers are cleared in the shooting of Victor Perez? And this is one many of you have. The Office of the Attorney General's role in this matter is limited to reviewing the investigation for potential criminal charges against the officers. We have concluded only that the state would be unable to prove beyond a reasonable doubt that the use of force was not justified. Our decision means the officers will not face criminal charges under Idaho law. In addition to the criminal investigation, the Pocatello Police Department conducted an administrative investigation to determine whether the officers complied with department policy and what, if any, employment consequences there should be for their actions. Our understanding is that there is also ongoing civil litigation over the critical incident. It would not be appropriate for us to express an opinion, and this letter does not express an opinion on any of those topics. So those are still happening. Now, as of now, I have... the Pocatello Police, I don't have a statement from them as far as the condition of the officers' employment. Once we get that, if we do get that, we'll bring that to you on eastidahonews.com. I also believe that there could be there's the lawsuit that's happening civilly. Has not been settled or anything, and so the city is restricted on what they can say. At least they say they're restricted on what they can and cannot say because they're in the middle of litigation. And every attorney tells their clients not to talk. So that is the decision on the Victor Perez situation. It is a tragedy all around. It's such a sad, sad story. But now the Attorney General has weighed in and the officers will not be charged. You can read the whole letter on eastidahonews.com. Would love to hear your thoughts about the matter, and we will continue to follow it. Thanks for watching. I'm Nate Eaton, eastidahonews.com.